So, question. Can an artificial intelligence be an inventor on a patent application? As it happens, the answer depends on where you are, and that's a problem. What I want to do today in this video is I want to talk about the state of AI inventorship, both where it is and isn't possible, and then I want to talk about sort of what that means for people who want to get protection across jurisdictions for inventions that, again, may have an AI inventor in one area but not in another. So let's start with the law. And I would say a month ago, if anyone had said, can an AI be an inventor? I would have said, no, that question basically doesn't even make sense. It's like saying, can a camera be a author for copyright purposes? I mean, technically a camera takes a picture, but no, that's silly. The photographer is the author, not the camera. And it doesn't matter if, there's some kind of a tool or technology involved. It's the human who's using it that is the author. And I would have said basically the same thing for being an inventor on a patent application. Doesn't matter if you're using a computer or a simulator or whatever it is, like a CAD, right? Computer-aided design. It's still the human using it who's the inventor. Well, about a month ago, there was a news story about a patent in South Africa that was granted to that had an AI as an inventor. And I said, what? And then I looked into it a little bit more, and I found out that South Africa has what we would call a registration system, which basically means the patents aren't evaluated the way they would be in the U.S. They just get basically like a stamp. So this wasn't really like saying, oh, South Africa has a, they've gone through the process and they've got a patent. It was saying, hey, South Africa has a different kind of a system. Under this system, because it's registration, they don't evaluate it. It got through. Okay, fine. So I said, okay, this is less than meets the eye, not a big deal. Then I heard about the case Thaler versus Commissioner of Patents. Thaler was the inventor on both the applicant, his AI was listed as the inventor on both the South African patent as well as the application in Thaler versus Commissioner. And that was an Australian case, and the Australian court said, yeah, you can have an AI as an inventor. And what the Australian court did, it went through, it talked about Australian law, which obviously I'm not really qualified to comment on, but, it said what it said, which is, you can be an inventor. It also said there was an issue if you don't have an AI as an inventor because, there are some cases where you really wouldn't have a human who did sort of the inventive act, and he, talked about what that meant. He said, a human... And if you say there's no such thing as an AI inventor, that would mean there's some inventions without any inventor, and that would mean they'd be excluded from the patent system, and that's bad. And so, they avoided that outcome by saying you could have an AI as an inventor in Australia. And I said, that is not what I would have expected. And then recently, I guess it was about a week ago, there was a case in the U.S. That was Thaler versus Hirschfeld. Decided in the district court for the Eastern District of Virginia, and they said, hey guys, under U.S. law, no, Thaler, you can't have an AI as an inventor. A human is an inventor, or a human can be an inventor, but, we're going to look at this. There's all this settled law. We're going to look at, the U.S. Definitions, and there's this word individual, and that's interpreted as being a natural person. So under U.S. law, clearly, AI inventorship, no go. All right, that is what I would have expected. And that's actually consistent with the position that the U.S. Patent Office came to in a study that they released last October saying, yeah, in general, people are of the opinion that our technology really hasn't advanced to the point where an AI could reasonably be called an inventor. Instead, if you've got something where, there's an AI involved, maybe the owner, the operator, person who fed it some data, the person who did the training data, but, there's going to be a human involved. It's not going to be an AI invention. And, that makes sense. There was also a UK High Court case where they basically said similar things. Actually, that was a funny one. So the UK High Court case, again, it said no AI inventor. It also said that, that Thaler didn't advance the position that he was the inventor because, he felt, that would be immoral. But, the judge said, I wouldn't think it's amiss if someone were to make the argument, right, that the human using the AI or training the AI or owner or what have you is the inventor. So that's kind of the state of the law we have right now. In South Africa, get a patent. Again, it's a registration system. We don't know really where the law is going to end up on that one. Australia, at least at the present time, you can't have an AI inventor. And there are apparently some patents where you have to have an AI inventor because there's no human inventor. In the US and the UK, and I suspect this will be the consensus position elsewhere, you cannot have an AI inventor, but the human who's using the AI probably is the inventor. All right, fine. So Australia's kind of an outlier. South Africa maybe is an outlier. What all does this mean? Well, here's the thing. Inventorship, it might seem like who really cares because it's the owner, right, of the patent, and inventors generally transfer their rights to some other entity. So like an employee generally is going to transfer their rights to the employer, even if they're the inventor. The problem is you've got different rules for what you'd call your priority claims, right? So if I have an invention and I make my invention in Australia, I might want to get a patent in the US because it's a big market. So I would go to the US and I'd say, hey, US, I filed my application in Australia, but I would like to get a patent in the U.S. Why don't you treat my Australian filing basically as a U.S. filing? I mean, it's not precisely like that, but that's a pretty good it's close enough to a pretty good summary, right? Well, in order to claim the priority, the U.S. has a rule that you have to be the same applicant. And if you look in the MPEP, this is section 213.02, I believe, it talks about the way the U.S. has its application to that rule. It says there has to be at least one inventor in common. Now, when you're talking about human inventors, that's not a big deal, right? So some jurisdictions say, oh, well, it's based on the disclosure, right? Who contributes to disclosure? Other jurisdictions, like the U.S., say it's about the claims, but it's going to be there's going to be some overlap. So, the fact that you need to have at least one inventor in common doesn't stop you from having a priority claim. However, when there's AI inventorship, especially given the reasoning of the Australian court where they said some inventions under Australian law have to have an AI inventor and cannot have a human inventor, you go to the US and we say, yeah, in the US, it's the operator, it's the human who's the inventor. You wouldn't have at least one common inventor. In Australia, there's the AI. In the US, there's a human. And at least under current practice, that means your potential right to get priority or get protection in the U.S. for your Australian invention is basically nullified. I would be interested to see how this pans out. I already know one way it pans out, right? In Thaler versus Hirschfeld, the application, they said you didn't file it with naming at least one inventor. You need to do this, corrected missing parts. He refused to do that, went to court. Has lost. Of course, he's appealing. Again, I feel his position under U.S. laws, I would expect he probably will not be successful in his appeal. But ultimately, if you're in a position, the patent system isn't supposed to say, hey, in Australia you can get protection, in the U.S. you can't get protection. I mean, yes, of course, sometimes you can, right? There's a difference in substantive law. But the idea that there's going to be a difference in this sort of priority claiming because of a new type of inventor, that's a different thing. That's a new thing. And I wonder if this becomes more common, right, for people to say there's an AI inventor, whether there might be some changes. But at the moment, again, we're in a little bit of a state of flux. A month ago, I wouldn't even have thought this is a relevant question. Now we've had, decisions. We have a patent, and as well as decisions in Australia and the U.S. Everything's under appeal. We'll see where it goes after that, but at the moment, I guess the moral of the story is know your inventorship rules in your relevant jurisdictions, and don't assume that these standard rules for priority claims and inventorship are going to apply when you have a very non-standard and non-human inventor. All right, thanks a lot. I will talk to you later. Bye-bye.